Tēnā koutou, tēnā koutou, tēnā koutou katoa. Holy Godin, tōku e na wā. Ko e te amo, tatai ture, te hang an nure, tate ture. Hello, I'm Lee Godin, the Dean of the Law Faculty here at Herenga, Waka, Victoria University of Wellington. It's my pleasure to welcome you tonight to the Ian Borrin Lecture for 2023.
Okay, it sounds as if it's working.
I think it probably is. Great. It certainly is. Thank you, everyone.
Yeah. So
and I think that I would like now to turn to give you a little snapshot of the Ian Borrin Lecture. And that lecture tonight is delivered in honour of Judge Ian Borrin, an alumnus and major supporter of the Victoria University of Wellington. Ian passed away in 2016. When Judge Ian Borrin was in practice, he practiced until 1983, when he was appointed to the District Court. He served as head of the Police Complaints Authority from 2001 until he retired in 2007. In 2010, with great generosity and foresight, he established the Ian Borrin Visiting Fellowship in Law at Herenga, Waka, Victoria University. The guiding aims of that fellowship are to enable scholars, academics, and members of the judiciary to visit the law school, to engage with the public through presentations and seminars, and more generally to enhance research by interacting with our staff and postgraduate students and the wider community. I'd very much like to acknowledge the generosity and also to welcome family members, extended family members of Greg and Jackie joining us here tonight. So thank you very much. Now, turning to our very distinguished visitor for the Ian Borrin Fellowship. After a number of false starts due to COVID, we are finally able to be inviting and welcoming Aileen to present to us tonight. So we're delighted to be hosting Professor Aileen Kavanagh of Trinity College, Dublin, as the 2023 Ian Borrin Fellow. Professor Kavanagh is the Chair of Constitutional Governance at Trinity College, Dublin, and the Director of TRICON, the Trinity Centre for Constitutional Governance. Formerly, Aileen was Professor of Constitutional Law at the University of Oxford. Aileen has written very widely in this field of constitutional theory, human rights, and comparative constitutional law. So you can see why we were very eager to have her come to speak to us here. She is the author of Constitutional Review under the UK Human Rights Act, 1998, published by Cambridge University Press in 2009. Her new book, The Collaborative Constitution, will also be published by Cambridge University Press, and it will be forthcoming very soon in August 2023. Please, everyone, join me in welcoming Professor Aileen Kavanagh.
I'm nervous about this mic. Does it work? Hold on. Now, does it work? It does. Okay. So many thanks to the Dean for her generous introduction and warm welcome to Te Herenga Waka, Victoria University of Wellington. Agrina Ushla, Garavila Mahakuf, Asok Quira Kofla Hula Hortam, yn nach agus asach dan fáilta fíorflaithúil a chur sibh Rome. I wanted to begin with some words in Gaelic, the indigenous language of my home country, Ireland, though we don't refer to it as an indigenous language. That is what it is from pre-colonial times. But it is now one of the 2 official languages of the Republic of Ireland since the founding of the state in 1937. So from one island country of deep and diverse heritage to another, I would say, Tena koto katoa, ko Aileen Kavanagh, toku inoa. Before beginning, I want to also extend my personal thanks to Ian Borrin and his wonderful partner, Jenny George, who keeps this legacy alive. It's a real honor to finally be here to give this lecture. I am conscious, as I think we all are at this particular time, and as I stand before you in this great university, the Victoria University of Wellington, how dependent we are as academics on this sort of funding and commitment and support to teach the next generation and to, at best, push back the frontiers of knowledge to make society better. So I'm aware of this and reflective of this, and I want to extend my deepest thanks to Ian Borrin. So in memory of him and in gratitude to Jenny for keeping this legacy alive, I'm incredibly grateful to be here. Whether you as the audience are as grateful for this beneficence remains to be seen, but I want to extend my heartfelt thanks. Okay, so the topic of the lecture tonight is declarations of incompatibility or inconsistency under the New Zealand Bill of Rights Act 1990 and the UK Human Rights Act 1998. Now, these declarations were a constitutional innovation of the 20th century, forged in the crucible of mutual exchange and constitutional borrowing between the United Kingdom and New Zealand. And in order to get under the skin of this strange constitutional beast, declarations of incompatibility, we need to embark on a process of deconstructing declarations. Now, the story begins here in Aotearoa, New Zealand, when the New Zealand Bill of Rights Act 1990 was enacted. It was hailed the world over as a remarkable innovation in constitutional design, which gave courts a significant power to protect rights, but crucially stopped short of allowing courts to strike down legislation. So under this Bill of Rights Act, as you know, the courts could interpret legislation compatibly with rights, but they could not invalidate legislation that was found to run contrary to them. Now, in the United Kingdom, for years, if not decades, we had struggled with this perennial conundrum of how to reconcile judicially protected rights with parliamentary sovereignty. This had vexed political actors in the UK for decades. But the New Zealand Bill of Rights Act provided both an inspiration and an exemplification of what could be done with statutory bills of rights. Building on the New Zealand template, the UK enacted the Human Rights Act of 1998, which gave the courts the power to interpret legislation compatibly with rights as in New Zealand. But what if courts were unable to interpret legislation compatibly with rights? What if that was not possible? Now, the New Zealand Bill of Rights Act was silent on this question. Building on this model, the UK came up with an innovation, which was the Declaration of Incompatibility. Courts could make a declaration that legislation was incompatible with rights, but this would have no effect on the validity or further effect of the legislation, nor was it binding, or did it have binding legal effect on the government of the day. Nonetheless, it empowered the courts to publicly announce to declare to the world that legislation enacted by the democratic legislature nonetheless violated rights, and that was no small thing. So under the Human Rights Act, judges could declare, but they could not disapply. They could adjudicate whether legislation was compatible with rights, but they could not invalidate legislation so found. So whilst it was clear what these declarations were not, they were emphatically not invalidation, questions loomed about what they actually were. Now, some harbored the worry that they were a form of strike down by stealth, a Trojan horse for American-style judicial review. But the main concern was on the other side of the spectrum. The worry was that they were a purely advisory rumination of the judges with no impact or effect either on the litigants before the court or the legislation in front of the judges. So therefore they appeared as advisory rather than adjudicatory, expository rather than a form of corrective justice. So it was not long before UK and comparative constitutional lawyers came up with answers to the nature of declarations of incompatibility. So one idea which became very popular was the idea that grouped New Zealand and the United Kingdom together as one new model of constitutionalism. So Stephen Gardbaum argued that under this new model in which New Zealand and the UK were a part of the same family, they decoupled rights-based review from judicial supremacy by giving the legislature the last word. And in this way of understanding declarations, they were not viewed as a veto against the policies of the nation, but rather a checking point in the system, an alerting and informing function of the courts in relation to rights. So aside from being a new model of constitutionalism, something new under the sun, Mark Tushnet from Harvard University argued that these statutory bills of rights were a form of weak form review. Now, certainly viewed from the vantage point of the American system, both the United Kingdom and New Zealand looked decidedly weak because the courts could not strike down legislation. Indeed, Mark Tushnet identified New Zealand as the weakest variant within this family of weak form review, because at that stage, the New Zealand courts only had interpretive, not declaratory powers. Another common way of understanding declarations was to view them as a form of constitutional dialogue, where the courts would share their opinion on rights, whereupon the legislature could ponder that opinion, mull over it, but ultimately have the right to disagree with it. Now, the common thread that links these three understandings of declarations is the key feature that the legislature has the right to override court decisions, and that those court decisions are provisional, non-binding, and non-final on the legislative branch. But in order to test the veracity of these comparative constitutional claims, these ways of understanding declarations, I think we need to look more closely at these declarations in their native constitutional habitats. And in this lecture, I'm going to first outline how they function and what effect they have in the UK system before, admittedly, tentatively, having a look at how they function and how they are evolving in the New Zealand context. So let's have a look at declarations of incompatibility under the UK model. So the first thing to note about these declarations in the UK context is that they are not a freestanding form of action. They're embedded within an intricate and carefully crafted legislative scheme and are interrelated with other provisions. The key feature about declarations is that they are a last resort only if the interpretive provision is not possible. In other words, if courts cannot interpret legislation compatibly with rights, then and only then can they issue a declaration of incompatibility. Now, the UK Supreme Court and the UK courts in general have settled on a principle that they will treat the interpretive provision, the obligation to interpret legislation compatibly with rights, as the primary remedial measure, thus leaving declarations as a matter of last resort. Why would they do so? Why would they emphasize interpretation and make declarations an exceptional remedy? Well, the key reason is that only a rights-compatible interpretation can deliver a remedy for the litigant before the court, precisely because that interpretation changes the meaning or clarifies the meaning of that legislation. That changes the law. This means that injunctions can be issued and consequences for the litigant can ensue. By contrast, a declaration of incompatibility leaves the litigant empty-handed. So judges trained in the English common law, attuned to the connection between right and remedy under the Latin maxim ubi jus ibi remedium, are inclined to go for interpretation rather than declaration, particularly in the context of criminal law claims. So even though this may have the effect, ironically, of inculcating adventurous forms of interpretation, it is precisely the weakness of the declaration of incompatibility that leads to heavy reliance on strong forms of interpretation. Now, this aligns with the general legislative purpose of the Human Rights Act, which was to give people in the United Kingdom speedy and effective domestic remedies for violations of their rights. So one of the aims was to prevent litigants needing to go to the Strasbourg court in order to get redress there. The idea was that litigants could go to the UK courts and have their rights remedied at source. In fact, this remedial purpose was so strong that the Lord Chancellor, when introducing the legislation in 1998, predicted and perhaps indirectly influenced and wanted to influence both judges and the political actors. He said that it would be possible in 99% of cases to interpret legislation compatibly with rights, leaving declarations for those very rare cases when it would be impossible to cure the incompatibility by interpretive means. So this emphasis on remedying rights leads UK courts to go for interpretations rather than declarations. Now, there is one other reason why courts favor interpretation rather than declaration, and that goes to the politics of litigation. So judges have extrajudicially commented on the phenomenon that when cases are presented before them in court, counsel for the state, counsel often represented by the Attorney General, urges the courts to find a rights-compatible interpretation in preference to a declaration of incompatibility. So Lord Phillips observed in an extrajudicial comment, he said, in his judicial experience, the creative use of Section 3, that is the interpretive provision, suits government ministers rather well. Ministers do not like declarations of incompatibility, provided that the main thrust of their legislation is not impaired. They have been happy that the courts should revise it to make it rights compliant rather than declare it to be incompatible. So many other judges have commented on this phenomenon that when cases are litigated before them, counsel for the state urges the courts very strongly to go for interpretation rather than a declaration. But then this goes back to the original understanding I portrayed, where declarations were part of a conversation between the branches. Now, if that is true, and declarations have no binding legal effect, they are merely advisory, merely a judicial view, why are governments so consistently resistant to allowing judges to share their view in the constitutional conversation? Well, the answer is that many governments do not want to incur the political costs involved in a headline-grabbing, damning verdict that legislation they have enacted violates rights. Even if a declaration has no effect on the validity of the legislation, it garners media attention, it stokes political opposition, it revs up the civil society groups who stand ready to critique the government for retaining the legislation. So whilst the declaration of incompatibility may look like the opening gambit in a constitutional conversation, the reality is that it carries significant political heft, such that governments don't want to receive them and do everything they can in the litigation process to avoid incurring them. So the upshot of all of these reasons, the remedial heft of an interpretation, the general purpose of the Human Rights Act, and the politics of litigation, means that declarations are a rare and exceptional event in the UK context. Since 1998, there have been just 34 declarations. That averages at one, mostly two a year. There has not been a deluge of declarations for the reasons that I've given. Now, I want to note one other feature of the declaratory jurisdiction. And that is that even in cases that come before the court, where the courts are sure that there is a violation of rights, there is a discernible trend before the UK Supreme Court of declining to declare. And they do so for a number of reasons. One reason is that they reject cases brought by interest groups or lobby groups, saying that we would have issued a declaration, but this applicant lacks standing. And they did this in a case concerning the Northern Ireland Human Rights Commission, where there was a clear violation of rights in relation to restrictive abortion legislation, but the UK Supreme Court declined to issue a declaration of incompatibility. Another situation is in relation to prisoner voting. It was repeat litigation, and the court said, well, we've already issued a declaration. It is not our job to pile on political pressure in order to remind the legislature of what it already knows, which is that the legislation violates rights. And in another case, the legislation, again, it was an old blasphemy law that clearly violated rights, but it had fallen into desuetude. And the court said, we are neither a debating club nor an advisory bureau. It is not our job to clean up the statute book, nor is it to chivvy the legislature to do so. So again, the courts were holding back from issuing declarations of incompatibility, even in contexts where the rights violation was clear. So the common thread through these cases of declining to declare, is a judicial concern to avoid becoming a channel for politics by other means, a firm determination to stem the floodgates of interest group litigation, and a commitment to anchor declarations in the facts of an individual case, and the traditional role of the courts in adjudicating disputes on the basis of facts presented before them in adversarial hearing. So for all the talk of declarations as dialogue, the UK courts have refused to be drawn into an advisory, expository, or interlocutory role vis-a-vis Parliament. Instead, they have remained cautious, reticent, you might say, emphasizing the importance of the traditional role of adjudication retrospectively, rather than sharing their opinion about rights to the government or the legislature in a free and liberal manner. So on closer inspection, now that we're deconstructing declarations, they're not as weak or as dialogic as they might have at first appeared. So I just want to outline for you a few other features of the declarations in the UK context, again, that reveals the hidden strengths of weak form review. So the first is that a declaration of incompatibility in the UK context triggers a fast track amendment procedure under Section 10 of the Human Rights Act. Now, this fast track procedure enables the government to quickly change legislation in response to a declaration of incompatibility. True, this fast track amendment procedure is not binding or obligatory. It is simply a power of the executive to change the law, not an obligation to do so. However, it means that the declarations in the UK context have a potent practical and legal effect. They open up the possibility of a significant executive power. It also reveals the underlying aim of the Human Rights Act, which was not to enable the legislature to override judicial rulings whenever they felt like it, but rather to enable and ease and facilitate swift compliance with judicial rulings whenever they were issued. The other key feature of the UK context is the international law dimension of the UK Human Rights Act, which doesn't apply, of course, in relation to the analogue here in New Zealand. So what happens is that when a declaration of incompatibility is issued in the UK context, this is not just an opinion of the UK courts that this piece of legislation violates rights. Instead, it is a municipal alert to the government and Parliament of non-compliance with international law. So as Lady Hale observed in one of the key cases in the UK, the declaration was designed as an early warning mechanism to the political actors that the United Kingdom is in breach of its international obligations. This has the consequence that the government knows full well that if they do not comply with the declaration now, there will almost inevitably be an adverse ruling of the Strasbourg court 5 years down the line. So therefore, there's very little that the government gains by refusing to comply with a declaration of incompatibility. When Strasbourg issues its declaration, then there is a binding legal obligation on the United Kingdom to comply with that ruling. So let's just have a quick overview of the practice to date of how the political actors in the UK have responded to declarations. So I've said there have been 34 declarations to date, 1 or 2 a year. What is interesting in comparative perspective with New Zealand is that there has been a near perfect, if not perfect, rate of compliance with every single declaration of incompatibility that has been issued by the UK courts. The only possible exception is prisoner voting, and I can talk more about that in questions if you wish. Just briefly, I would say that that saga in relation to prisoner voting was focused more on the Strasbourg court, not on the domestic declaration of incompatibility. Therefore, it's not a clear example of the UK government and parliament firmly resisting a domestic declaration. If we code this case, the prisoner voting case, as compliance, then we have a clean sweep, a perfect rate of compliance with every single declaration since 1998. So this fact alone reveals that there is more to the declaration than meets the eye. It is not like an optional opinion in a constitutional conversation. It is carrying far more political, legal, and constitutional weight than might at first appear. Now, you might say, and many people say, the reason for this high rate of compliance is the fear of adverse litigation in Strasbourg. And from a comparative point of view, you could then conclude, well, this is irrelevant to the New Zealand experience. However, having analysed the parliamentary debates and the committee reports in response to every single declaration under the UK Human Rights Act, what I would say is, yes, clearly and obviously the Strasbourg dimension has a big role to play. However, it is not by any means the only factor. Political actors, both in the House of Commons and in the House of Lords, have stood up and said, when judges hand down a declaratory ruling that our legislation violates rights on grounds of the principle of the rule of law, respect for the independence of the judiciary, and our duty of comity towards the judicial branch, we as a government in a rule of law country follow those rulings and do something to implement them. So it's not the case that the only reason for compliance here is fear of an adverse ruling from Strasbourg. There is an internal sense of normative obligation on behalf of political actors that in a country that respects the rule of law, when the court hands down such an adverse ruling, the political actors, respond in a way that addresses that incompatibility. Now, of the 34 declarations, there have been, most of them have been uncontroversial, but 4 of them have been highly controversial, those relating to prisoner voting, the sex offenders register case, criminal sentencing, and counterterrorism. In those 4 cases, yes, the political actors had fierce and resistant political rhetoric counteracting the declarations. But at the end of the day, often behind closed doors and away from the limelight of the media, they implemented those declarations in some form. So that's the picture from the United Kingdom, and it stands against the comparative understanding that declarations are nothing but the opening gambit in a constitutional conversation. So turning now to New Zealand, and I'm conscious that this seemed like a good idea when I was preparing this lecture in my study in Oxford, and less good perhaps now as I stand before some of the founding fathers of the New Zealand Bill of Rights Act. Nonetheless, sometimes a view from the outside and from afar can shed some light on the nature and the complexities involved in these mechanisms, which of course we share to some extent. Okay, the Bill of Rights Act in New Zealand. So in contrast to the UK Human Rights Act, which was an intricately designed, carefully crafted, single statutory scheme, which was designed to reconcile all of these competing dimensions, it is fair to say, I think, that the New Zealand Bill of Rights Act is not cut from whole constitutional cloth. In fact, it is a constitutional coat of many colors, mixing leftover material from previous garments. This means that there are some gaps, some irregularities in the design, which judges have to smooth out and weave together. Now, one such gap, perhaps, was that there is no mention of a declaration of inconsistency. The courts are told that they can and must give preference to a rights-compatible interpretation. And they are most emphatically told that they must not invalidate legislation. So if a Bill of Rights or a Bill of Rights Act is like the constitutional commandments, Section 4 is a firm, thou shalt not clause. But what about this area, this territory between interpretation and invalidation? Well, the judges had to pick up the constitutional baton. And in the first cases, right from the beginning of the Bill of Rights Act, there were some subtle intimations about what courts could do if they couldn't interpret compatibly. Then in Hansen, there were informal indications. And in some cases, there was even some talk of judicial proclamations. But it took the Taylor case on prisoner voting in 2019, so very recently, where the New Zealand Supreme Court finally accepted that they had the power to issue a declaration of inconsistency. Now, given the fact that the New Zealand courts had circled around this possibility for years, if not decades, and given the fact that this legislation was clearly in violation of rights guaranteed under the Bill of Rights Act, as I understand it, the Taylor decision was not controversial. However, it is an elegant, if not spare, decision where some questions are still left unanswered. Are these declarations advisory or adjudicatory? Are they optional or are they obligatory? Are they abstract statements of judicial opinion, or are they anchored in the facts of a particular case? And if judges issue them, what is the expected response of the political actors? Some of these questions are still left open following the Taylor case. Now, my own view is that the best way of deconstructing declarations is to resist these binary questions. In fact, the declaration has adjudicatory components as well as advisory implications for the political actors. They are legally optional, but that does not mean to say that they are not politically obligatory in some sense. They are anchored in the facts of a particular case. They must be brought before the court with a litigant before them, but they have an abstract or general quality which vindicates and confirms rights in a general way. When I looked closely at the Taylor decision, I noticed in particular in Chief Justice Shan Elias's judgment that she reflected this composite nature of the declaration, saying that they are a form of authoritative advice, thus straddling the divide between a purely advisory or a strictly obligatory jurisdiction. Now, I want to talk about what Taylor does not deal with. And one of them is that they do not reiterate the statement made in Hansen about the reasonable constitutional expectation that the political actors would appraise and reappraise the legislation found to be incompatible with rights. And in some paragraphs, they explicitly disassociate themselves with some comments made in the Court of Appeal in Taylor. And in those comments, the court said that they should have a restrained role, that when engaging in declaration, they should be conscious of their position in the constitutional scheme. So whilst the Court of Appeal reflected on the nature of the relationship between the courts and the political actors, characterizing it as one of a collaborative enterprise where each branch has a role to play, but must nonetheless respect the role of the others, the Supreme Court in Taylor explicitly rejected and affirmed any association with those comments. It is hard as an outsider to understand why that was the case. Nonetheless, the Taylor decision found the jurisdiction, but did not engage in these broader reflections on what the implication is for their relationship with the political actors. So the upshot is that these declarations do not undermine the validity of legislation, but Chief Justice Sian Elias said they nonetheless withhold the legitimacy that comes with the compliance with rights. And that indeed is no small matter. Now, in between the Court of Appeal decision and the Supreme Court decision, the government in New Zealand already announced that Kavanagh would consider legislating in order to formalize the declaratory jurisdiction. And indeed, after the Taylor decision, they did so, amending the New Zealand Bill of Rights Act to set in train a series of procedures that would follow once judges had issued a declaration. This seemed to me to be a very positive development, an instantiation of this collaborative enterprise where the legislature could see that the courts had, in a sense, no other option but to issue these declarations. But they stepped in to defend the courts, I think, from the accusation of adventurism and activism, of them seeming as if they are trying to bring upon themselves, arrogate to themselves, a novel declaratory jurisdiction. So in enacting the legislation in this way, the government and Parliament took courts seriously as partners in the collaborative enterprise, defending them against these accusations. It's also an example of the Parliament taking rights seriously as well, honouring its own obligation and rising to that obligation to say that when the courts issue a ruling that our legislation violates rights, we will take those declarations seriously. So the procedural requirement to debate those issues, to reflect on them, and to put them to a parliamentary committee is important. It's also an example of the Parliament taking declarations seriously as not just an optional view in a constitutional conversation, but something of great constitutional, legal, and political moment. Now, I'll just make one final point before closing. In the Privileges Committee report, which recommended this amendment to the New Zealand Bill of Rights Act, it did not mention one innovation which was crucial in the UK context, and that is the Joint Committee on Human Rights, which is a key locus for rights protection in the UK Parliament. Now, of course, the UK Parliament is much larger than the New Zealand Parliament. It has, of course, the upper chamber, and peers in the House of Lords have been hugely significant in enhancing accountability for rights. Nonetheless, this committee of both houses of the British Parliament have worked together with House of Lords peers, with backbenchers in the House of Commons, with civil society groups, and with the House of Lords Constitution Committee to strengthen the accountability architecture for protecting rights. Now, there was no mention of such a committee in the New Zealand context, but nonetheless, it is important to note that when the New Zealand Bill of Rights Act was enacted, there was a suggestion in that initial Justice and Law Reform Committee report, crafted in part by Sir Geoffrey Palmer, who's here tonight, and Sir Kenneth Keith as well, that there should be such a committee in the New Zealand context. If the New Zealand accountability architecture is attenuated to some degree with lower capacity amongst a very small parliament by international standards, the importance of parliament rising to its own responsibility to protect rights would argue in favour of increasing that capacity and building up institutional memory within a specialised human rights committee that would work within the House of Representatives. So I'll circle back to where I began. When the UK Human Rights Act was enacted and the New Zealand Bill of Rights Act before it, comparative constitutional lawyers, many of whom will descend on Wellington next week, characterised New Zealand and the UK as being part of the same constitutional family. And indeed, we are a family. We have the same constitutional heritage, a belief in the same values, including parliamentary sovereignty and representative government on the Westminster model. And there are also some of the same constitutional quirks. However, there is divergence as well as convergence between both of the systems. And moreover, though viewed from the outside, our family looks weak. Viewed from within, I'm seeing a lot of strength, robustness, and indeed muscularity in some of the judicial decisions. Now, in the UK context, there is what Justice Tipping described as adventurous interpretation in the UK courts. I would characterise the Fitzgerald's decision here in New Zealand as also erring on the adventurous side. Then when you look at the declarations, these are not treated in the UK, at least, as optional statements. They have enormous political and constitutional effect. On the New Zealand side, one of the striking contrasts with the UK is the very liberal view of standing. The Make It 16 case, which was a declaration of incompatibility following Taylor, it was taken as read that Make It 16, an interest group, a lobby group, had standing to bring that case and to achieve a declaration. So in various ways, though divergent and sometimes convergent, there are hidden strengths to weak form review. And in deconstructing declarations, I've tried to show these strengths, some of which we share. Thank you.
Thanks to our guest Professor Aileen Kavanagh for a wonderful set of remarks. My name's Dean Knight, and it's my pleasure just to help facilitate the Q&A, because we've got about 10 minutes left before we adjourn for drinks outside. And so in the usual way, if you can signal to me and catch my eye, there'll be a microphone which will come around shortly. And if you'd be kind enough to introduce yourself when you make your question. And so I'll just catch my eye. I've got a couple of hands coming up already, but I wonder if before we launch into them, I could just check where the questions might be coming from shortly. Thank you. We might just start just in the front here.
Thank you. I'm just a concerned citizen. I might be the one in this room with the least legal knowledge, but thank you for the great talk. I have really serious concern about the government, how they abused their power in the last 2-3 years. And we have medical bureaucrats brag about how they managed to make something illegal become legal within 9 days about a lockdown law regulation, and a whole lot of very fast-tracked under emergency. The legislation actually make a lot of them seriously violate our Bill of Rights and even human rights. But it doesn't seem to be, there seem to be no power. They become like a decoration. And we people don't know how to stop it when government overreach like this. What's the alternative for people to do it? Like you mentioned, committee, or I don't really know.
Right. Well, thank you. That's a very important question, and I do appreciate how controversial the lockdown laws have been in New Zealand. There are a number of solutions here, and one is to have stronger accountability mechanisms within the Parliament. So what you need is critical voices and counteracting voices within the Parliament so that the Parliament can hold the government to account. That is the primary way in which government can be held to account. Some people say, well, why can't courts strike down legislation? One accountability route would be to give courts stronger powers. I think that is not germane to the constitutional tradition that exists here in New Zealand or in the United Kingdom. I don't see this happening anytime soon. But looking at the accountability mechanisms within Parliament, that, it seems to me, is something that could be looked at here, given the small Parliament and therefore the limits on capacity that exist in terms of holding the government to account.
Thank you. Now I've got Sir Jeffrey next.
Thank you very much. That was a wonderfully informative lecture. It's quite helpful to understand the differences between the UK and New Zealand. New Zealand has always been something of an executive paradise because there is no upper house, and it's a very small House of Representatives with 120 members, and 28 of them are in the executive. And the backbenchers on the government side don't have a lot of incentive to hold the government to account. They want to survive politically. And so you have a comprehensive select committee system to do scrutiny, but a lot of them are very young and inexperienced members because the high ones get to be ministers. In fact, everyone in New Zealand wants to be a minister. None wants to be a backbencher. So the problem is that when we had these legal opinions given to the Parliament about the infringement of the Bill of Rights Act, the select committees didn't really have the expertise to know what to do about them, and they had a very inconsistent and unfortunate history about it. And that is what led to the developments that you've mentioned.
Yes.
Repeatedly, academics asked for a human rights committee to be set up so a set of principles and practice could be developed. That's never been done. And it's really basically because there is such a small body of people who don't necessarily have the expertise. So there was just one other thing I'd just really like to ask. The reports we get here in New Zealand are that you don't know whether your Bill of Rights is going to survive or not. Every time there's a change of minister, there seems to be a change of policy. I'd be very interested to hear what the latest situation is there.
In the UK, you mean? Yeah. So I mean, you make this point about the limits on capacity in the New Zealand Parliament, and you struck a pessimistic tone on this. And yet, what I take away from looking at the New Zealand context over these 40 years, including your role within it, is the potential for optimism, the potential for, in a sense, a small group of people to say, we need to change this, and we will change this. It is true that viewed in comparative global perspective, the New Zealand Parliament is small, obviously a unicameral parliament. The limits on capacity, I totally agree. But it seems to me that it's not a foregone conclusion that this could not be changed. And maybe there will be some appetite to do so. On the UK context and the Human Rights Act, so yes, the UK Human Rights Act has been on political death row for over 10 years. So the first 10 years, it survived quite well, even though post 9/11, there were some grumblings then, even by the Prime Minister, Tony Blair, that had enacted it only a couple of years beforehand. They all of a sudden realized this really does restrict what we can do. And they didn't want that. When the Conservative government came in about 2010, that rhetoric was ratcheted up, not only against the Human Rights Act, but against the jurisdiction of the Strasbourg court. And so academics, political actors, and judges also are very aware of the vulnerability and fragility of the Human Rights Act. Nonetheless, year in, year out, despite that rhetoric, despite that constant grumbling about it, it still stays on the statute book. Now, there was a danger that Dominic Raab would succeed in bringing in a kind of major overhaul of the Human Rights Act, which he called a Bill of Rights Act, but it was, in a sense, anything but. My sense is that the Human Rights Act is like an awkward part of the body politic that the politicians don't really like, and they try to resist it. It also, of course, garners good political capital if they come out and say, we don't want to give sex offenders and murderers rights. But nonetheless, they have complied with every single declaration of incompatibility. They have never overridden a judicial interpretation, no matter how adventurous that has been. And that includes rape shield legislation and all sorts of measures that they were against. So my sense is that these two, that there is a tension there, but it has survived thus far, and my prediction is that it will continue to do so.
We might have time for perhaps one, maybe another two questions. Yeah, did I catch one? Was it Ben? I think it was just there. But anybody else interested in a question? Thank you.
Thanks very much. My name is Ben Keith. I'm a barrister who, among other things, does some of these cases. And related to someone who wrote the Act. But my question is, or my first comment was just, part of the context of the New Zealand Act is New Zealand's commitment to the International Covenant on Civil and Political Rights. So we do have a Strasbourg analogue, whether that's quite, it obviously has a different structure, but some of the early comments about declarations of inconsistency here make hopeful comments that, for instance, a declaration might be taken into account by the Human Rights Committee under the Covenant. That was just a comment. My question is more about the infrastructure, and it's a little bit following Sir Geoffrey's comment. The experience, particularly of cases like Make It 16 and of the passage of the new provisions of the Bill of Rights Act, have presupposed that there will be robust engagement by the executive government. But we see, for example, in Make It 16 that the executive government didn't actually call any evidence and tried to have the case dismissed on the basis that the government hadn't thought about this recently, so it shouldn't have to defend it. That was ignored by the court, but it did also mean that the declaration the court made was rather tentative, and the reaction to it was was quite critical. So I suppose my question is, how, if one were looking from the UK experience, including the near-death experience with Dominic Raab, how does one grow that executive culture? Because we do seem not to have it working at the moment. of robust engagement. Thanks very much. It was a great lecture.
So thank you. That's a fascinating question. And I think it has two sides. So one is, how do you grow the culture within the executive or the legislative branch? And the other is, how cognizant should courts be of the impact of these declarations on the executive and legislative branch? So just dealing with the first aspect, in the UK, they bedded in robust mechanisms of internal review within the executive branch. They didn't have to do so. They weren't required to do so by the Human Rights Act, but they did. And those mechanisms have remained. You have kind of build teams with legislative proposals that have legal advisors. They engage in an iterative way with the Attorney General, with the government legal advice, and so on. It is quite robust. They make every effort to ensure that when they present bills to Parliament, that they can say truthfully, we believe this complies with rights. They adjust legislation prophylactically to ensure that that is the case. So even though there might not be a flashy debate on the floor of the House of Commons about this legislation potentially violating rights, what happens is that the government prophylactically acts to avoid that by trying to do their human rights homework within the government. And then in the legislative branch, the Joint Committee on Human Rights is absolutely pivotal to keeping the government on its toes. One aspect of the question you raised, though you didn't raise it directly, was, should the courts be thinking about the impacts that these declarations have? And I thought in the Make It 16 case, there was almost a sense of, well, we think it violates rights, and, you know, let the chips fall where they may. In the UK courts, there is a distinct concern about how these declarations will land, and therefore a caution and a reticence before issuing these declarations, except in those cases where it is absolutely necessary. And the consequence of that is, first, obviously, there aren't that many declarations. But second, when they are issued, they are in the clearest of cases, so that then the government and the legislature, if you like, repay the favor back to the courts and say, okay, this is a clear violation of rights, and in a country that respects the rule of law, we will do our best to accommodate it. So there's a reciprocity there. There is a mutual respect, and there is a degree of judicial caution and restraint before handing down these declarations.
Now, if we just have the microphone here for Nicole. Thank you.
Thank you. I'm Nicole Moore. I'm a professor here at the law school. I hope this is a simple question. I just wanted to ask, can you envisage a situation where Strasbourg might say that there's been no breach of the convention in spite of the court saying that there was an inconsistency with the Human Rights Act?
Yeah, it's conceivable, but it's not likely. So it's not highly likely, but it's conceivable. It could arise maybe in a situation where the Strasbourg court, uses its called margin of appreciation. But in general terms, when the UK court hands down a declaration, they have already engaged in depth with the Strasbourg decisions, and their own decision in a way replicates the reasoning and follows the, generally follows the precedent of the Strasbourg court. So that it's a pretty reliable indicator that the Strasbourg court will agree. Moreover, when it comes to Strasbourg, you imagine a litigant from any state party to the convention coming before the Strasbourg court, especially when it's a country with a reputation for respecting rights, like the United Kingdom, despite all the, Boris Johnson problems and so on, which tarnish the reputation. But in general, and historically, and even despite Boris Johnson, this is the case. If the litigant comes before the Strasbourg court and says, well, the UK Supreme Court have looked at it in depth and in context and found a clear violation of rights, because of course, if it's unclear, vague, then the courts can interpret the legislation compatibly with rights. So a declaration is by definition a situation where the violation is so clear, so patent, that they cannot massage the meaning in order to deliver a rights compatible outcome. In that context, it's possible, but it's hard to conceive of a situation where the Strasbourg court, especially now, would go against the UK Supreme Court. And it has had its fingers burnt, of course, on the prisoner voting issue, where they held that the blanket ban on prisoner voting violated rights. The Strasbourg court, I assume, rues the day that they issued that declaration, because it caused such a political uproar in the United Kingdom. And for what? You know, in the end of all, the UK Parliament did introduce prisoner voting for a very tiny category of prisoners, but the end of the saga was a depletion of the political capital of the Strasbourg court, a depletion of the reputation of the United Kingdom for protecting rights and respecting court rulings. No one came out looking good from that saga. And partly because of that, the Strasbourg court now are very cautious in relation to UK jurisprudence. Thank you.
Well, on that note, I think it's come time to close our formal proceedings before we break for this match fizzy drink. But my final duty, and really it is a privilege, is to once again thank our guests, because I think we've been treated to a delightful comparative story about declarations, dialogue and the like. And I think the eye from abroad has been really thought-provoking and will inevitably cause us to reflect differently on our way of doing Bill of Rights and inter-institutional conversations. And on behalf of our audience, I'd like to say we especially appreciate the care that Aileen has brought to the topic, and also the intellectual energy that you've carried with you while visiting us here at Herenga Waka. You really are a perfect holder of the Borrin Fellowship, and I echo the thanks to the Borrin whānau for their continuous support of this opportunity. And we really look forward to continuing in these conversations with you, Aileen, as you'll be joining us as a keynote speaker next week at our ICONS conference, when 500 public law scholars from around the world converge on Wellington. I'll just hold the desk for a while. It's going to be a great time. We look forward to pick up on these points. So with that, can you please join with me in thanking our guests, Professor Aileen?